I was staring out my kitchen window at the frozen expanse of Winterbourne Lake when I saw them 3 trucks pulling what looked like small wooden sheds onto the ice. My ice. My lake. The property I'd inherited from my grandfather just 6 months ago in northern Minnesota, right outside the town of Bemidji. "What the hell?" I muttered, grabbing my coat and boots. The February wind hit me like a slap when I stepped outside, but I barely noticed. I was too focused on the 4 people setting up what were clearly ice fishing cabins on my private lake. I marched down the slope from my house, my boots crunching through the snow-covered path I'd shoveled earlier that week. As I got closer, I could make out the figures better. 3 men were hauling supplies while a woman with short blonde hair stood there holding a clipboard, directing them like she was orchestrating a symphony. "Excuse me," I called out as I approached. "What exactly do you think you're doing?" The woman turned, and I immediately recognized that look. That particular blend of entitlement and irritation that comes from someone who believes they're absolutely in the right. She was probably in her mid-50s, wearing a puffy North Face jacket that looked brand new, and had that trademark, "I want to speak to the manager" energy radiating off her. "We're setting up our community ice fishing cabins," she said, as if that explained everything. "I'm Patricia Hendricks, president of the Winterbourne Estates Homeowners Association. You must be new here. I'm Grant Vickers, and this is my lake, private property." Patricia's smile didn't waver. "Oh, I don't think so. This lake has been used by the community for decades. It's a tradition. Every winter, we set up fishing cabins for our residents. Just because you bought one of the properties doesn't mean you can disrupt our community activities." I didn't buy it, I inherited it. From my grandfather, Gerald Vickers, and he owned this entire lake, which means I own this entire lake. One of the men, a stocky guy in his 40s with a thick beard, chuckled. "Come on, buddy. Don't be that guy. It's just for a few weeks. We've been doing this for years." "Not on private property, you haven't." Patricia's expression hardened. "I've reviewed the community bylaws extensively. This lake borders the HOA community, which means it's part of our shared resources. Bordering doesn't mean owning," I said, my patience already wearing thin. "I want these cabins off my lake by tomorrow, or I'm calling the sheriff." Patricia made a show of writing something on her clipboard. "I'll be filing a formal complaint with the county. You can't just deny the community access to resources they've used for years." "There's something called adverse possession, Mr. Vickers. You might want to look it up." I had looked it up, actually. When I'd inherited the property, I'd spent weeks going through all the legal paperwork with my grandfather's lawyer. The lake was entirely on my property, and the 20-year continuous use requirement for adverse possession in Minnesota hadn't been met. My grandfather had only stopped allowing community access 3 years ago after the HOA had tried to fine him for not maintaining community standards on his private property. "You might want to look up property deeds," I shot back. "I'll be here tomorrow at noon. If these cabins are still here, the sheriff will be too." I turned and walked back to my house, hearing Patricia say something to her companions that I couldn't quite make out, followed by laughter. They clearly didn't take me seriously. That night, I pulled out all the documentation my grandfather had left me. The property survey clearly showed the lake's boundaries, all of which fell within my land. The deed was ironclad. I even found a folder labeled HOA Disputes that detailed several arguments my grandfather had had with Patricia and her predecessors over the years. Apparently, the Winterbourne Estates HOA had been trying to claim access rights to the lake for the better part of a decade. My grandfather had allowed limited access at first, being a good neighbor, but things had soured when the HOA tried to enforce their rules on his property. They'd sent him violation notices for everything from his unkempt lawn to his unsightly dock. When he'd told them to get lost, they tried to claim the lake was a shared community resource. The next morning, I called the Beltrami County Sheriff's Office and explained the situation. Deputy Marshal confirmed they could send someone out if the trespassers refused to leave. Armed with this information, I waited. Noon came. The cabins were still there. In fact, there were now 2 more, and I could see people inside them through the small windows. Actual people fishing on my lake like they had every right to be there. I called the sheriff's office. Deputy Marshal himself showed up about 45 minutes later, his cruiser pulling up my driveway. "Mr. Vickers," he said, stepping out. He was a tall man in his 50s with graying hair and a professional demeanor. "You called about trespassers?" "Yes, sir, on my lake." I showed him the property documents, the deed, everything. He studied them carefully, then nodded. "Seems pretty clear to me. Let's go have a conversation with these folks." We walked down to the lake together. Patricia was there again, along with 7 or 8 other people now. Some were fishing, others were just hanging around the cabins drinking what looked like hot cocoa. "Afternoon, Mrs. Hendricks," Deputy Marshal said. "I'm afraid I'm going to have to ask you and your group to pack up and leave. This is private property." Patricia's face flushed red. "That's absurd. We have every right to be here. This is a community resource. Do you have documentation showing ownership or legal easement to this property?" the deputy asked calmly. "Well, no, but then I'm afraid Mr. Vickers is within his rights to ask you to leave. You have until sunset today to remove these structures, or I'll have to issue citations for trespassing." "This is harassment," Patricia sputtered. "I'll be contacting the county commissioner. My husband plays golf with him." "That's your right, madam, but the law is the law. Please remove your structures by sunset." I watched as Patricia and her group grudgingly began packing up. The look she gave me as she passed could have frozen the lake twice over. "You're going to regret this," she hissed. "I doubt it," I replied. Deputy Marshal stayed until they'd loaded the first cabin onto a trailer, then tipped his hat to me. "You might want to post some no trespassing signs, just to make things crystal clear." "I'll do that. Thanks for your help. Just doing my job. Though I'll warn you, the HOA around here can be persistent. My sister lives in Winterbourne Estates. Patricia Hendricks once fined her $200 because her mailbox was the wrong shade of black. Seriously, just watch yourself." He wasn't kidding about them being persistent. The next morning, I found an official-looking letter in my mailbox. It was from the Winterbourne Estates HOA Legal Committee, informing me that they were pursuing legal action for denial of community access to shared resources and violation of long-standing community agreements. I called my lawyer, Tom Patterson, who'd handled my grandfather's estate. He read the letter and actually laughed. "They've got nothing," he said. "Your grandfather dealt with this same nonsense. They're bluffing, trying to intimidate you. Just ignore it. What if they don't give up? Then we file a restraining order if they keep trespassing." "But honestly, Grant, they're probably just testing you. Stand your ground and they'll back off." Tom was wrong about them backing off. Over the next week, I received 3 more legal threats, each more elaborate than the last. They claimed community tradition, implied easement, and even tried to argue that my grandfather had given verbal permission that constituted a binding agreement. Then things got weirder. I started getting violation notices. The HOA was sending me formal citations for violations of their community standards. My house needed repainting. My driveway had cracks. My mailbox wasn't regulation. Each notice came with a fine, ranging from $50 to $300. The problem was, my property wasn't in the HOA. It was outside their jurisdiction entirely. My grandfather had made sure of that decades ago when the development was first built. His land predated the HOA by 30 years. I collected all the notices and took them to Tom. "This is harassment," he said, reviewing them. "They're trying to bully you into compliance. Don't pay a single fine. These have no legal standing." "So what do I do?" "Document everything. Keep every letter, every notice. If they keep this up, we'll have grounds for a harassment lawsuit." February turned into early March, and the ice on the lake was still thick enough for fishing. I'd started enjoying my morning coffee while watching the sunrise over the frozen expanse, peaceful and private. Then one morning, I looked out and saw them again. The cabins were back. All 6 of them, plus what looked like a larger structure that might have been a communal warming house. I couldn't believe it. They'd actually come back onto my property after being told by law enforcement to stay off. This time I didn't even bother walking down there. I called Deputy Marshal directly, and he sounded annoyed when I explained the situation. "They're back. After I explicitly told them to stay off, every single cabin plus a few more. I'll be right there." 20 minutes later, 2 sheriff's vehicles pulled up. Deputy Marshal brought a younger deputy with him, and both of them looked serious. "This is now criminal trespassing," Marshal said. "They were warned. Let's go document this." We walked down to the lake, and this time there were even more people than before. It looked like a little village on the ice. I counted at least 15 people. Patricia was there, of course, standing in front of the warming house with her arms crossed. "Mrs. Hendricks," Deputy Marshal said, pulling out his citation book. "I'm issuing you a citation for criminal trespassing. You were explicitly warned to stay off this property." "We're exercising our community rights," Patricia said defiantly. "We've consulted with our own attorney, and he assures us we're within our legal bounds. This lake has been used by our community for over a decade, which establishes precedent." "I don't care what your attorney says," Marshall replied. "I care about the property deed, which clearly shows this lake belongs to Mr. Vickers. You have 2 hours to remove these structures, or I'll be arresting people for trespassing." "You wouldn't dare. Try me, madam." For a moment, I thought Patricia might actually call his bluff, but something in Marshall's expression must have convinced her he was serious. She turned to the group behind her. "Everyone, start packing up. We're leaving under protest. This isn't over." Deputy Marshal wrote her a citation anyway, along with citations for 3 other HOA board members he recognized. Each one was for $250. After they left, I thanked the deputies again. "You need to put up a fence or something," the younger deputy said. "Maybe some cameras. People like this don't quit easy." "I'm on a fixed income," I admitted. "I inherited the property, but I'm a freelance graphic designer. Money's tight." "Well, at least get some trail cameras from the hardware store, $50 each, and they'll give you proof if they come back." I took his advice and bought 3 trail cameras that afternoon, setting them up around the lake's access points. I also printed out large no trespassing signs and posted them every 50 feet around the lake's perimeter. For about a week, things were quiet. Then I checked the trail cameras. They'd been back. At night, the footage showed Patricia and 2 men I didn't recognize walking around the lake's edge, taking measurements and photographs. They were being careful not to actually go onto the ice, staying just at the boundary line. I wasn't sure what they were planning, but it couldn't be good. The answer came in the form of another letter, this one from something called the Bemidji Regional Planning Commission. It stated that a complaint had been filed regarding environmental concerns about my property, specifically about unsafe ice conditions and lack of proper safety measures on the lake. An inspector would be coming to evaluate the property the following week. I called Tom Patterson immediately. "They're trying every angle they can think of," he said after I read him the letter. "The good news is it's your private property. You don't need safety measures for the public because the public isn't allowed there. Should I be worried about this inspection? No, but be cooperative. Let them do their job, explain the situation, and it'll be fine." The inspector, a tired-looking man named David Chen, showed up on a Wednesday morning. I gave him the full tour, explained the situation with the HOA, and showed him all my documentation. "Yeah, this complaint seemed odd to me," he admitted. "The person who filed it claimed this was a public lake with inadequate safety infrastructure. But if it's private property, none of those regulations apply. I'll file my report saying everything's in order. Thanks. Sorry you had to drive out here for nothing. Not your fault. Though between you and me, Mrs. Hendricks files complaints with our office about once a month. We've learned to take them with a grain of salt. After he left, I felt a small sense of victory. They were throwing everything they could at me, but none of it was sticking. Then March hit its midpoint and the weather started warming up. The ice was getting thinner, which meant the fishing season was basically over. I figured I'd won. They couldn't set up cabins on thin ice, and by the time next winter rolled around, I'd have a full year of documented ownership and they'd have to give up. I was naive. The ice had barely melted when I received a certified letter from something called the Winterbourne Estates HOA Legal Trust. This wasn't just a letter from Patricia anymore. This was from an actual law firm in Minneapolis, Chandler and Reeves. They were suing me for $150,000. The lawsuit claimed that by denying the community access to the lake, I had caused emotional distress, loss of recreational opportunities, and diminishment of property values for Winterbourne Estates residents. They were also seeking a permanent easement to the lake for historical community use. I sat at my kitchen table, staring at the lawsuit papers, feeling like I'd been punched in the gut. I didn't have $150,000. I barely had $1,500 in my savings account. Tom Patterson was less amused when I showed him the lawsuit. "Okay, this is more serious," he admitted. "But it's also a massive overreach. They're hoping you'll settle out of fear. Don't panic, we can fight this." "How much is this going to cost me?" Tom was quiet for a moment. "I can work with you on payment plans, but Grant, you might want to consider a counterclaim." "For what?" "Harassment, trespassing, filing frivolous lawsuits. We document everything they've done and we turn this around on them." "Will that work?" "It'll definitely make them think twice about continuing this nonsense." We spent the next 2 weeks preparing our response. Tom filed a motion to dismiss their lawsuit while simultaneously filing a counterclaim for harassment, trespassing, and what he called abuse of legal process. We asked for legal fees, damages, and a permanent injunction preventing the HOA from coming onto my property. The court date was set for early May, which gave me about 6 weeks of anxious waiting. During that time, the harassment continued. More fake violation notices, more complaint letters. Someone even called the fire department claiming they'd seen smoke coming from my property and worried it was an uncontrolled burn. It wasn't. I didn't even have a fire pit. April brought rain and the full melt of the lake. It also brought a new tactic from the HOA. They started organizing. I began seeing posts on social media, on a Facebook group called Winterbourne Estates Community. Patricia had painted me as a villain. According to her posts, I was an outsider trying to destroy community traditions and denying families access to recreational activities they'd enjoyed for years. She encouraged residents to attend the court hearing to show the judge how important this issue is. Some of the comments were reasonable people pointing out that private property is private property, but others were vicious. People I'd never met were calling me selfish, greedy, and worse. Tom told me to stay off social media and not engage. Anything you say can and will be used against you in court. Let them rant. It doesn't change the facts. The hearing finally arrived on May 7th. I put on my only suit, met Tom at the courthouse in Bemidji, and tried not to throw up from nerves. The courtroom was packed. Patricia had made good on her promise to bring the community. There must have been 30 people there, all wearing blue ribbons that said, "Save our lake." Our lake. They were calling it our lake. Judge Martha Reynolds, a stern woman in her 60s, called the court to order. The HOA's lawyer went first, a smooth-talking guy named Richard Chandler, who made it sound like I was single-handedly destroying the fabric of the community. Your Honor, Winterbourne Estates is built on the principle of community, of neighbors coming together, sharing resources, and creating traditions that bind them. The lake has been central to that community for over 12 years. Families have created memories there. Children have learned to fish there. To suddenly deny them access is not only cruel, it's legally questionable given the years of established use. Tom stood up when it was his turn. Your Honor, this isn't about being cruel. This is about property rights. The deed is clear. The survey is clear. Mr. Vickers owns this lake. The HOA has no legal claim to it, no easement, and no right to trespass repeatedly after being warned by law enforcement. They've harassed my client, filed false complaints, and are now trying to use the legal system to bully him into giving up his property rights. This lawsuit should be dismissed, and their behavior needs to be stopped. Judge Reynolds asked several questions about the property survey, the history of use, and the specific incidents of trespassing. She reviewed the police reports, the citations, and all the documentation we'd provided. Then she surprised everyone. "I'm not issuing a ruling today," she said. "This is more complex than a simple trespassing dispute. Both parties will have time to submit additional briefs. I want a complete history of property access, any written or verbal agreements, and a detailed account of all interactions between Mr. Vickers and the HOA. We'll reconvene in 30 days, 30 more days of uncertainty." I could see the satisfaction on Patricia's face as we left the courtroom. She thought the delay meant she was winning. Tom was less concerned. "This is actually good for us. It gives us more time to document their harassment, and it means the judge is taking this seriously instead of just rubber stamping their claim." Over the next month, Tom and I put together what he called an airtight case. We documented every single interaction, every fake violation notice, every trespassing incident. We got statements from Deputy Marshal. We even found 3 neighbors from the HOA who were willing to testify that Patricia had pressured them to support the lawsuit even though they didn't care about the lake. One of those neighbors, a nice woman named Susan Porter, was particularly helpful. "Patricia runs that HOA like her own personal kingdom," Susan told me when I met her at a coffee shop in Bemidji. "She's forced out 2 board members who disagreed with her. Most of us are just afraid to say anything because she'll make our lives hell. But this lake thing, it's ridiculous. Everyone knows it's your property. Would you be willing to testify to that?" "Absolutely. I'm sick of her bullying people." The second hearing in early June was different. This time, only a handful of HOA supporters showed up. Maybe they were losing enthusiasm, or maybe they'd realized the facts weren't on their side. Tom presented our case methodically. The property survey, the deed, the history of my grandfather's ownership, the police reports documenting trespassing, the fake violation notices showing harassment, Susan's testimony about Patricia's intimidation tactics. The HOA's lawyer tried to argue that community tradition should carry weight, But Judge Reynolds shut that down. Tradition doesn't override property rights, Mr. Chandler. Unless you can show me a legal easement or some form of documented agreement, your clients have no claim to this lake. Your Honor, surely the years of use do not meet the legal standard for adverse possession in Minnesota, as I'm sure you're aware. This lake was used with the permission of the previous owner who later revoked that permission. There's no continuous hostile use for the required 20 years. I felt a surge of hope. Judge Reynolds got it. She understood the law. After both sides rested, she didn't hesitate this time. I'm dismissing the HOA's lawsuit in its entirety. Furthermore, I'm granting Mr. Vickers' motion for a permanent injunction. The Winterbourne Estates HOA and its members are prohibited from trespassing on Mr. Vickers' property, including the lake. Any further violations will result in contempt of court charges. As for the counterclaim regarding harassment, I'm finding in favor of Mr. Vickers and ordering the HOA to pay his legal fees, which I'm setting at $15,000. This behavior has been unconscionable, and it needs to stop. The gavel came down, and I felt like I could breathe for the first time in months. Patricia looked like she'd swallowed a lemon. She stood up and actually pointed at me. "This isn't over. We'll appeal, Mrs. Hendricks," Judge Reynolds said sharply. "I suggest you consult with your attorney before making any more threats in my courtroom. You've lost. Accept it and move on." Outside the courthouse, Tom shook my hand. "That went better than I expected. $15,000 should cover most of my fees and give you a little cushion. And the injunction means if they come back, they're not just dealing with trespassing charges anymore. They'll be in contempt of court. So it's really over, it should be, though I'd keep those trail cameras up just in case." Summer arrived, and for the first time since I'd inherited the property, I actually got to enjoy it. The lake was beautiful in warm weather. I bought a cheap kayak and spent evenings paddling around, watching the sun set over the water. The HOA paid the $15,000, though Tom said they'd tried to negotiate it down first. I used part of it to pay off my remaining legal bills and put the rest into savings. It felt good to have a financial cushion again. I didn't hear anything from Patricia or the HOA for months. No violation notices, no harassment, no trespassing. The trail cameras showed nothing but deer and the occasional raccoon. I started to think it really was over. Then October came, and with it, a cold snap that hit northern Minnesota early. By mid-November, the lake was already starting to freeze at the edges. I'll admit, I got a little paranoid. I checked the trail cameras daily. I walked the perimeter of the lake every few days, looking for signs of intrusion. But there was nothing. December arrived and the lake froze solid. Beautiful, pristine, and empty. Then, on the morning of December 18th, I woke up to the sound of trucks. I looked out the window and felt my blood pressure spike. They were back. Not just back this time, there were 8 cabins being set up on the ice, plus the warming house, plus what looked like a storage shed. I couldn't believe it. After everything, after the court order, after the injunction, they were actually back on my lake. I grabbed my phone and called Deputy Marshal. "They're in violation of a court order," he said grimly. "I'm on my way and I'm bringing backup. This is now a criminal matter." 3 sheriff's vehicles showed up within 30 minutes. Deputy Marshal, 2 other deputies, and even the sheriff himself, a heavy-set man named Thomas Griggs. We walked down to the lake as a group, and I could see the people setting up the cabins freeze when they saw the law enforcement presence. Patricia was there, naturally, directing operations. When she saw us, her face went pale, but she stood her ground. "Mrs. Hendricks," Sheriff Griggs said in a booming voice, "you're in violation of a court order. I'm placing you under arrest for criminal trespassing and contempt of court. You can't arrest me for using community property." Patricia shrieked. "It's not community property, and yes, I can. Turn around and put your hands behind your back." I watched, somewhat stunned, as they actually handcuffed her. Two other HOA board members who were there, a man named Douglas Freeman and a woman named Carol Zimmerman, were also arrested. The rest of the people scattered quickly, abandoning the cabins and rushing to their vehicles. "What about all this?" I asked, gesturing to the cabins. "We'll need you to document everything for evidence," Deputy Marshal said. "Take photos, note where everything is. After the trial, if they're convicted, we can discuss removal. For now, it's evidence of a crime scene." Over the next few days, the story became local news. HOA president arrested for defying court order ran in the Bemidji Pioneer. The comments section was split between people defending Patricia and people calling her entitled and delusional. Tom Patterson was thrilled when I called him. "This is perfect," he said. "Not only do they face criminal charges, but you now have grounds for additional civil penalties. They violated a court order. That's serious." The criminal trial was set for January, which meant the cabin sat on my frozen lake through Christmas like bizarre holiday decorations. I documented everything, took hundreds of photos, and waited. During this time, something interesting happened. I started getting calls from some Winterbourne Estates residents. Not hostile calls, but apologetic ones. A man named Robert Chen called to say he'd always thought Patricia was overstepping, but had been too afraid to speak up. A woman named Jennifer Moore said she'd voted against the continued legal action, but had been outvoted by the board. Several others reached out to distance themselves from Patricia's actions and assure me that not everyone in the HOA supported this crusade. "We just want to live in our homes in peace," Robert told me. "Patricia's obsession with this lake has cost us all money in legal fees and made the whole community look bad. Most of us are hoping she gets voted out at the next election." The trial in January was swift. Patricia, Douglas, and Carol all faced charges of criminal trespassing and contempt of court. Their lawyer tried to argue that they'd misunderstood the court order, but Judge Reynolds wasn't buying it. "The order was explicit and clear," she said. "Stay off the property." Instead, you organized another large-scale trespassing event with multiple structures and numerous people. This wasn't a misunderstanding. This was deliberate defiance of a court order. All three were found guilty. Patricia was sentenced to 30 days in jail, though the sentence was suspended pending completion of 200 hours of community service and payment of additional fines. Douglas and Carol got smaller penalties, as they'd clearly been following Patricia's lead. But the real consequence came from the civil side. Tom filed another motion, and Judge Reynolds ordered the HOA to pay an additional $45,000 in damages and legal fees for the contempt violation. "This organization has demonstrated a pattern of harassment and illegal behavior," Judge Reynolds said. "These penalties are designed to ensure it stops." The HOA didn't have $45,000 readily available. They'd already depleted their reserves with the previous legal battles. That meant they had to levy a special assessment on all the Winterbourne Estates homeowners, about $300 each. You can imagine how popular that made Patricia. By March, she'd been recalled from the HOA board by a vote of the membership. Robert Chen was elected the new president, and one of his first acts was to send me a formal apology letter on behalf of the association. I accepted it graciously, though I kept my trail cameras up and my guard raised. Spring came again, and I watched the ice melt with relief. Another winter survived, another battle won. But here's where the story takes an interesting turn. In late April, I got a knock on my door. It was Robert Chen and two other new HOA board members. "Mr. Vickers, we'd like to talk to you about a proposal," Robert said. "May we come in?" Curious, I invited them to my kitchen table and made coffee. "First, let me say again how sorry we are about everything that happened," Robert began. "Patricia's behavior was inexcusable. But here's the thing, a lot of families in our community really did enjoy ice fishing on the lake. It was a genuine tradition for many people, especially families with kids. We were hoping we might be able to come to some kind of arrangement." "What kind of arrangement?" I asked, wary. "We'd like to lease access to the lake from you, officially, legally, with a proper contract. We'd pay you a fair rate. We'd agree to all your rules and regulations, and we'd carry liability insurance so you're not at risk. We're not trying to claim ownership or anything like that. We just want to see if there's a way everyone can benefit." I sat back, surprised. "How much are we talking?" "We were thinking $5,000 for the winter season, December through February. Plus we'd handle all the logistics permits if needed, safety equipment, cleanup. You wouldn't have to do anything except cash the check. $5,000 would make a real difference to me. It would cover my property taxes for the year with money left over. And the truth was, I didn't really use the lake much in winter. I wasn't a fisherman myself. I'd need everything in writing," I said. "A real contract reviewed by my lawyer. And first sign of any problems, any violation of the agreement, the deal is off and you leave immediately." "Absolutely. We expected nothing less." Over the next month, Tom Patterson and the HOA's new lawyer worked out an agreement. It was 20 pages long and covered every possible scenario. The HOA would have access to the lake from December 1st through February 28th. They could have up to 6 fishing cabins, no more. They had to carry $2 million in liability insurance, naming me as an additional insured. They had to provide safety equipment, follow all state regulations, and remove everything by March 1st. Any violations would result in immediate termination of the agreement. Most importantly, the contract explicitly stated that this was a lease agreement and granted no ownership rights, easement rights, or any other permanent claims to the property. I signed it in June, and the HOA paid me the $5,000 upfront. When December rolled around, I watched nervously as they set up the cabins again, but this time was different. Robert personally came to my door to introduce himself and the volunteer coordinator. They showed me their insurance paperwork. They explained their safety protocols. And you know what? It was fine. Better than fine. The families who used the cabins were respectful. They stayed within the designated areas. When February ended, they removed everything on time and even left the area cleaner than they'd found it. I renewed the lease for the next winter and the winter after that. By the third year, I raised the rate to $7,500, and they agreed without complaint. The money helped me fix up my house, upgrade my work equipment, and finally build up a proper emergency fund. Patricia never came back. I heard through the grapevine that she and her husband moved to Arizona, probably to terrorize a whole new HOA somewhere in the desert. The criminal record from her contempt conviction remained, though. I checked. A permanent reminder that property rights matter, and that no amount of entitlement or community tradition can override the law. It's been 5 years now since I first inherited this property. The lake still freezes every winter, and the ice fishing cabins still go up. But now they're there legally, with my permission, generating income that's helped me turn my grandfather's inheritance into a real home. I've even made friends with some of the Winterbourne Estates residents. Robert and I grab beers occasionally. His kids sometimes come over to see the lake in the summer. It turns out that when people treat you with respect and follow the law, it's pretty easy to be neighborly. Last week, I got a call from a documentary filmmaker. Apparently, my story had made the rounds on social media and some legal podcasts. She wanted to interview me about standing up to HOA overreach. I politely declined. I'm not looking for fame or attention. I just wanted to keep what was mine and be left in peace. But I did frame one thing. It's hanging in my office now. It's the judge's order from that first trial, the one dismissing the HOA's lawsuit and establishing my property rights. Right below that, I hung a copy of the lease agreement. Together, they tell the story perfectly. First, I had to fight for what was mine. Then, once my rights were established and respected, I was willing to share on my own terms. That's not just the story of my lake. That's the story of how property rights are supposed to work. I'm sitting at my desk now, looking out at the frozen lake. There are 4 cabins out there today. Inside them are families fishing, drinking hot chocolate, making memories. And somewhere in the HOA office, there's a check being prepared for this season's lease payment. It's funny how things work out. Patricia wanted to take what wasn't hers, and it cost her everything: her reputation, her position, her criminal record, and eventually her home. I wanted to protect what was mine, and by standing firm, I ended up with both security and income. The lake is still frozen. The cabins are still there. But now everything is exactly as it should be: legal, respectful, and fair. My grandfather would be proud. He fought these battles for years, never backing down, never letting them bully him into giving up what was his. When he left me this property, he left me more than just land. He left me a lesson about standing your ground and not letting entitled people steamroll your rights. I learned that lesson well. And every winter, when I look out at those cabins on the ice and think about the deposit in my bank account, I'm reminded that doing the right thing, even when it's hard, even when it's expensive, even when it seems easier to just give in, eventually pays off. The lake is mine. It's always been mine. And now, everyone finally accepts that. That's all I ever wanted.